On June 7, 1892, Homer Plessy boarded an East Louisiana Railroad train. He sat down in the whites-only section. However, there was a problem. Homer Plessy was mixed race and accordingly was not entitled to sit in the whites-only railroad car. The whites-only railroad car, along with its upgrades and other traveling privileges, were designated for white patrons only and backed by Louisiana's 1890 Louisiana Separate Car Act. Homer Plessy's eventual arrest as a violation of the Louisiana Car Act led to the Supreme Court case Plessy versus Ferguson. In that case, Homer Plessy utilized the Equal Protection Clause of the 14th Amendment to argue his case. On May 18, 1896, the Supreme Court of the United States rejected Plessy's argument, instituting that separate facilities for non-white persons and white persons was both legal and constitutional. As a result, whiteness was not only further enshrined with rights to exclude by law, but also became a type of property whereby rights were recognized in that if infringed upon, claims could be both made and acknowledged in court. But how do these areas of property rights and race, both which are social constructions, converge? Our reading for this week's lecture provides insight. Let's talk about it. Hello everyone and welcome to today's lecture. So today we begin with the lived experience of Homer Plessy in Louisiana. We begin with him to really map this space of beginning to understand the impact of race in society and how law works to reaffirm what happens to Black people, persons of color, and white persons as well within society. And toward that end, we move our attention from the racial contract over to Cheryl Harris's reading Whiteness as Property, which is a law article in the Harvard Law Review. However, in order to understand Cheryl Harris's Whiteness as Property, the understanding of the social contract is important. So if you have not had an opportunity to watch week 1 lectures, make sure you go back and watch them so that way you understand the full context of what it is we are getting at here. So with that being stated, let's go ahead and get started. What is our roadmap for today? So our roadmap, what we're going to do is we are going to begin with a flashback. We are going to be talking about Mills and the racial contract, setting a definition, and then we're going to move over into defining what property is in this particular instance and understanding it, property rights, property law, and different things of that sort. And then we are going to talk about the affirmation of the amalgamation of race and property in its interest being protected in law. So let's go ahead and get started so we can get things underway. So beginning with our flashback, remember what the racial contract is. It is a tacit socio-political agreement which serves as the supporting substructure or the underwriting element upon which the social contract itself is established. This is going to come to be very, very important in understanding what Cheryl Harris is getting at in understanding whiteness as property and the argument that she is making here. Because like Charles Mills, for Professor Harris, this is not just something that is theoretical. It is real and it is born of a lived experience. Notice she starts this article with the lived experience of her grandmother and how her grandmother was able to pass as white yet carried the burdens of blackness, right? So make sure you did the reading and you know exactly what I'm talking about here. But why is understanding the racial contract before we lean into whiteness is property important? It is because the racial contract permits the treatment and social positioning of those who are subjected to inequality and marginalization in society. It allows that particular type of lived experience to be interpreted as being equal to those who are favorably positioned by the social contract. In other words, that the inequity of society is seen as equal according to the terms of the contract. So with that being stated and that in the background, let's move forward and make sure you hold that in your mind. What is property, right? When we think about property, what is it? And in this instance, I just don't want you to think about real estate and different things of that sort, but quite literally, what is property and how does it come about? How does property even come to be a thing as a colonial technology? And in order to understand this, we must go back to week 1, lecture 2, and thinking about John Locke, Thomas Hobbes, as well as Jean-Jacques Rousseau. These names should all sound familiar. And there are 3 different theoretical approaches that I want us to consider in thinking through what is property. And remember, what we're talking about here is the legal construction of property and how the idea in the construction of property, being able to own, comes about. So there is the founding theoretical approach. There is the traditional theoretical application and approach of property, and there is the modern theoretical application and approach of property. When we're talking about the founding theoretical approach, we're really talking about folks like John Locke, Thomas Hobbes, those folks that we addressed week 1, lecture 2. When we're talking about the traditional theoretical approach, we're talking about folks like James Madison, right? Who Professor Harris referred to in her article. And when we talk about modern theoretical applications, we are talking about the ways in which courts 20th century and later, so our time, think about property and apply its application. So let's look at the founding theoretical approach. So the founding theoretical approach says this about property, that property is not limited to external objects and people's relationships to them, but also all of those human rights, liberties, powers, and immunities that are important for human well-being, including freedom of expression, i.e. freedom of speech. Some of this should sound familiar. Freedom of conscience, freedom from bodily harm, and free and equal opportunities to use personal faculties. Now, all of this sounds good and well and ready to go. However, we know that when we refer back to folks like Thomas Hobbes and John Locke, who they had in mind when they came up and conceptualized the category of human, that certain persons were rendered as human while others were not, and that the qualifier for human within their philosophical approach was racialized, and all others were subjected to that particular racialized demographic. So then all those humans who had the right to enjoy rights, liberties, powers, immunities, etc., were then, according to Western colonial development, white folks, because those who were non-white persons were not seen as human in that particular era and time. So the original notion of rights, liberties, powers, and immunities that come up out of the social contract are only made possible and are marshaled out to society via race. And this is how whiteness in its origins becomes a type of property that extends a right. Now, let's make this a little bit more clear. So, an example, you might have a driver's license. That driver's license gives you a right to operate a motorized vehicle of a certain class. However, you cannot necessarily go out on the road and drive a 16-wheeler. You need a CDL to do that. So in this instance, whiteness is operating as a technology, as a type of property to extend rights, protections, liberties, and powers to folks who retain that actual license of what? Whiteness. Right? Again, this is the founding theoretical approach and how John Locke, Thomas Hobbes, Jean-Jacques Rousseau, etc. are placing qualifiers along the lines of human. So then we know that what it means to be socially conscribed as human or socially rendered as human, what it means to receive rights, liberties, powers, and immunities, all of those things are socially constructed because they derive from whiteness. Therefore, whiteness comes to act as a type of property that extends and guarantees and ensures rights. Okay? Along those lines, then we move to the traditional theoretical application of property. In other words, what happens when they get here to the States? Who is today the founding fathers? And Cheryl Harris, Professor Harris, refers to James Madison in this particular instance. She actually quotes him, and she says that, quote, property, his particular approach was that, quote, property embraces everything to which a man, and there are qualifiers to man, not only gender, but also race. Therefore, you cannot understand race without gender, and you cannot understand gender without race. And we will talk about gender in a couple of weeks, right? But he is qualifying who may have access to property and therefore rights here. So James Madison says, quote, property embraces everything to which a man may attach a value and have a right, meaning legal rights. And what you have to remember is that in law, the words and or are very, very significant. And James Madison here says that a man may attach a value to the property and have a right within the property. So in this instance, the property has two functions: that it retains a value, whether social, political, or economically, and it extends a right. It has a dual function. Okay? Now, along those lines, what should we be thinking about here? Cheryl Harris says this on page 1726, that white identity conferred tangible and economically valuable benefits and was jealously guarded as a valued, there's the value, possession allowed only to those who met a strict standard. One more time, that white identity conferred tangible and economically valuable benefits and was jealously guarded as a valued possession. Remember what we just said about a dual function of value and extending rights. And it only came to those who met a strict standard. Now we're going to put a pin right there, because what we want to do is we want to break down these different levels of scrutiny as it relates to constitutional law. And if you went to law school, if you know somebody that went to law school, or you're familiar with law, you know that within constitutional law, there are three different levels of scrutiny. There is rational basis, there is immediate scrutiny, and there is strict scrutiny, right? And just keep you all with me, we're on a sidetrack here. So put your pin in James Madison. We're going to come back to him in just about 2 minutes. Now, when it comes to a rational basis scrutiny, what this means is that someone who is bringing a complaint must prove that whatever law the government is trying to pass is not rational, that it interrupts something. This usually relates to licensing and regulations, right? The next two levels of intermediate and strict, the government has to prove that what it wants to do is tailored in some specific way to where it has this specific effect. So, an example, with intermediate scrutiny, the government must prove an action or classification is substantially related to an important government interest, okay? This usually involves cases that may infringe upon rights of a protected class. So we would think about cases such as United States versus Virginia, where the Supreme Court ruled that the Virginia Military Institute male-only admission policy violated the Equal Protection Clause. But here we have to ask, the Equal Protection Clause for who? That is, I'll let you think of the answer for that. because that gives away what we're going to be going into when we talk about critical race feminism, right? But in either case, that's the intermediate level of scrutiny. The next level of scrutiny is strict scrutiny. The same standard by which Cheryl Harris says that whiteness is property is only allowed to those who met a strict standard. And what is the strict scrutiny? What is the strict standard? It says that government must prove that a law is narrowly tailored to achieve a compelling interest. This usually involves cases that deals with fundamental rights, race, affirmative action, zoning, etc. Right? And for those of you who are law students or students of the law or practitioners of law, you can see where the boundary is being pushed here, right? And where the definition is being critiqued here. Remember the critical in critical race theory, that the government must prove that a law is narrowly tailored to achieve a specific compelling interest. Remember, there is interest in property because property is both valuable and does what? Extend rights. And in order to make sure that there is a compelling interest, the government must do a few things. A, that interest, it must serve a compelling interest to the state, the nation state, that the preservation of whatever this is must serve a compelling interest to the nation state in its preservation. That B, that it must be narrowly tailored to serve that specific interest. That whatever law, whatever opinion is going to come up out of whatever case, that it must be narrowly tailored to serve the interest of that thing. Some of you all see where this is going. And that C, that it be the least restrictive means possible to achieve that interest. Now let's go back to what Cheryl Harris has stated here, that white identity conferred tangible, and this is on page 1726 if you're looking at the PDF. She says that white identity conferred tangible and economically valuable benefits and was jealously guarded as a valued possession, allowed only to those who met a strict standard. In other words, for you to take advantage of whiteness as a type of property that had value and extended rights, you had to meet a strict standard of proof of whiteness because it served the compelling interests of the state and the preservation of the state, because it is narrowly tailored, because only specified demographics can take advantage of it, and it's the least restrictive means because it doesn't place a burden upon those who may and or may not qualify as white, that it's easy for them to come in, if you will, right? So toward this end, why does this become important in unpacking and understanding whiteness as property and getting at what James Madison is pointing toward, and also what John Locke and Thomas Hobbes is pointing toward in the founding theoretical approach? And it is because, as Cheryl Harris says, quote, law's construction of whiteness defines and affirms critical aspects of identity. In other words, who is white? It is narrowly tailored, and we're going to be laying out some other definitions of that. So law's construction of whiteness defines and affirms critical aspects of identity, who is white, privilege, who benefits will come as a result of that particular status, and of property, what legal entitlements arise from that status. Let's go back to Homer Plessy in this particular instance. And we see how law is being what? Narrowly tailored along the lines of a what? Strict scrutiny. So in looking at the example of Homer Plessy in his experience with the train, law's construction of whiteness defined and affirmed critical aspects of identity. So much so that Homer Plessy, who was of mixed race origin, right, was not able to sit in the whites only car because it had been narrowly tailored. The definition of whiteness had been narrowly tailored. Also, privilege, what benefits accrue to that status. So he could not sit in the comfortable chairs, the plush chairs that were in the whites only train car. He had to sit in the train car that was marked for non-white persons that did not have those same amenities. Privileges, right? And of property. What legal entitlements arise from that status, down to where one could sit, how one would be served. In this particular instance, if one will be arrested and classified as a criminal. Therefore, what is who and who is not a criminal and what is a crime is also what? Socially constructed. Right? I hope all of this is coming together and starting to make sense. So then, right, one of the problems that folks have is says, well, whiteness is intangible. It's not something that you can hold. It's not a piece of tangible property. Herein comes the modern theoretical application of property. And the modern theoretical application of property says this, that it consists of rights in things that are intangible or whose existence is a matter of legal definition. In other words, something can be intangible that gives you a right to something. When you acquire a piece of property, words are intangible, lettering intangible, but the arrangement of those words and letters when you sign your signature gives you a right to something that is tangible. And in this instance, whiteness as something that is intangible extends rights to something that is valuable, intangible, and can accrue more wealth. This is, by the way, this goes back to week 1, how the social contract is passed down from generation to generation to generation. Right? Because they are what? Benefactors. Even if they are not what? Signatories. So in this way, understanding what property is allows us to get at something. What is that something? That the social contract, which in and of itself is underwritten by the racial contract, guarantees access to property both tangible and intangible. And in turn, whiteness as an intangible property ensures access to rights, political recognition, and social privilege. And how is that done? By going back and understanding that the founding theoretical approach of property classifies who is and is not human, and therefore who gets access to rights, liberties, powers, and immunities, etc. Which then moves over into the traditional theoretical application of the property, who is the founding fathers, where it says that that same property embraces everything to which a man may attach a value and have a legal right. Do you all see the social construction that is happening here? These are the things that society is built off of. And we're going to get into some more tangible examples in just a minute here. And now, knowing the traditional theoretical application of property, we can then move over to the modern theoretical application of property, which says that property doesn't have to be something tangible, that it can be something intangible, such as being a beneficiary to a contract that gives you rights to make a claim on something via a propertized intangible asset, such as whiteness. Now that we understand what property is, that it can be something that is both tangible and intangible, and that it accrues and ascribes value as well as extend rights, let's lean into Cheryl Harris's argument that law propertizes whiteness. And as a result of propertizing whiteness, only a certain demographic is allowed certain rights and privileges in society. So how do we get to this argument? How does Cheryl Harris lean into this idea that not only is whiteness a social construction in doing a certain work in society, but that it is something that is actually propertized and protected in law? Let's begin by looking at the historical context, right? By looking at the colonization of native and indigenous lands. And what we have to understand here is the rule of first possession and what that is. What you also have to carry into this moment with you is what we learned from week 1. And that is the colonial mindset, that inverted epistemology that Charles Mills was talking about, that misinterprets and misunderstands the world intentionally. Because what we have to understand about native folks and indigenous folks is that land is to be something that is taken care of. That land is not something that does the bidding of capitalism. Land is not something that can be owned, but that we are stewards of the land. However, the colonial mindset, the inverted epistemology that misinterprets the world, sees land as something completely different, right? Let's look at page 1721 of what Cheryl Harris says here. And she says, although natives were not the first occupants and possessors of the land of the New World, their racial and cultural otherness allowed this fact to be reinterpreted and ultimately erased as a basis for asserting rights in the land. Why? Because the land had been left in its natural state, untilled and unmarked by human hands. It was, quote, a waste, and therefore the appropriate object of settlement and appropriation. There is that inverted epistemology, that colonial mindset going to work, well, technically waste, but nonetheless, but going to work, that the founding fathers and those who were colonizing what we now call the United States, what they were seeing. This has to do with one's worldview, right? Cheryl Harris continues. She says, thus the possession maintained by natives was not true possession because the land was not being built upon, that it wasn't doing the work of capitalism, that it wasn't doing the bidding of the nation state in producing armory that had the capacity to take life, etc. Right? She says, thus the possession maintained by natives was not true possession and could safely be ignored. Remember what Charles Mills said when we were going over that painting in terms of when the Declaration of Independence was being signed, that the presence of a society that was already there had to be ignored in order for this demographic of folk to be able to say, we're going to build a society here and we are superior. Not only did that happen in that moment, but also dispossession was allowed to take place. Why? Because native caretaking of the land was not seen as true first possession. And accordingly, this interpretation of the rule of first possession effectively rendered the rights of first possessors contingent on the race of the possessor. In other words, that one could only possess the land by way of the European colonial mindset because of the inverted epistemology, misinterpreting the world that is required. And accordingly, only particular forms of possession, those that were characteristic of white settlement, what is that? Tearing up the ground, building, chopping down trees, no respect for animal life, etc. Those characteristics of white settlement would be recognized and legitimated via what? Law. This is why CRT studies law. And accordingly, when we flip over to the next page on 1723, when we're looking at the case Johnson and Graham's Lacey versus McIntosh, the holding from that case ruled this, that natives could only convey to the latter. In other words, they could only, this case is talking about who could obtain land from native peoples. And in this case, they were saying that only the government could do so because the government was, acquiring all of this land. But in any case, it goes on to say, in holding that natives could only convey to the latter, the court reasoned that native title was subordinate to the absolute title of the sovereign. Who is the erected and created sovereign at this particular point in time? The United States. And that was achieved by conquest because, quote, conquest gives a title which the courts of the conqueror cannot deny. And in this instance, European being affiliated with whiteness does the conquering, does the rule of first possession, and thus only they can possess the land. And in this instance, race and property, or race as property, or whiteness as property becomes what? Enshrined in law. Let's take a look at another example. Slavery, right? So black folk become propertized. That's why we call it chattel slavery. Black folk become propertized in enslavement. It could only be laid claim to, in other words, purchased, sold, and traded via whiteness. Only white folk were allowed to purchase those who were to be enslaved and those who were enslaved. Therefore, whiteness became a form of property whereby the right to enslave and own was guaranteed, as black persons who were enslaved were legally and socially excluded as human. Therefore, whiteness rendered one as human, and by way of that whiteness, one could participate in the slave trade. And they could buy, and they could acquire, and they could enslave. And so the rights of whiteness become recognized in law because slavery was legal. And one's ability to practice in slavery was predicated upon group membership in what? Whiteness. And in this instance, whiteness becomes propertized in law. How? Because there are certain things that one should be able to do via enslavement. Right? Let's take a look at another one. The Constitution. So the Constitution says this: we, the people of the United States. And by the way, this is 1788. So we know who we, the people, are. We looked at this when we looked at the Declaration. It says this: we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves. There it is. To ourselves and who? Our posterity. Do ordain and establish this Constitution for who? The United States of America. That when they wrote out the Constitution, it was for themselves and their posterity. This is how one cannot be a signatory of the contract, but is a beneficiary of the contract. And how is that contract passed down? Because whiteness in and of itself becomes propertized. Because we, the people of the United States, is predicated upon what? Racialized belonging. And accordingly, you get the justice, the domestic tranquility, and providing for the common defense. And in this way, the we and the qualifications of we become enshrined in law and propertized because it extends the right of justice. It extends the right of the general welfare. It extends the right to secure the blessings of liberty to who? Ourselves and our posterity. What also takes place within the Constitution to let us know that they are demarcating persons is the 3/5 clause. When those who are enslaved are rendered as 3/5 a person for the purposes of taxation and what? representation in Congress. And what did that do? That allowed those who were plantation owners to make greater rights. But those rights were extended by way of what? Their whiteness. So therefore, whiteness was protected in what? Law, because they were not rendered as what? 3/5 a person. This is how whiteness becomes a form of property. A property that is jealously guarded, that is protected by way of strict scrutiny, because either one qualifies or they do not, right? And it has certain interests. It does a certain thing, right? Now you all are probably beginning to see why there is this open debate in CRT, because it goes deep into the weeds. Now let's take a look at something that's even more for it, the Naturalization Act of 1790. And it said this, quote, that be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that any alien other than an alien enemy, being a free white person who shall have resided within the limits and under the jurisdiction of the United States for the term of 2 years, may be admitted to become a citizen. In other words, here we have an explicit, as opposed to implicit, example wherein the law makes clear that in order to qualify for citizenship, that one must belong to a specific demographic. And what it also makes clear is that if you do not belong to that demographic, then you are, quote, an alien enemy. That was the Naturalization Act of 1790, demonstrating how whiteness becomes propertized in law and how whiteness as a type of property both accrues and ascribes value and extends rights. And in this case, that right being citizenship. Now, bells should be going off in heads, because there's a certain group of folk who wants to go back to the 1790s. And could this be what they are referring to, right? So the Constitution is ratified in 1788, and we understand what they meant by we the people. And then they followed that up with the Naturalization Act of 1790, right? And what that makes very, very clear is as what Cheryl Harris lays out on page 1730. When she says that, quote, the inequalities that are produced and reproduced are not givens or inevitabilities, but rather are conscious selections regarding the what? Structuring of social relations. In this sense, it is not contended that property rights and interests are not natural, but are what? Creations of law. Okay, let's move a little bit further. So after we get the Naturalization Act of 1790, then we can look at the Black Codes. The Black Codes come about after the Civil War. And what were the Black Codes? The Black Codes disallowed Black persons who were formerly enslaved from participating in voting, integrating equally into society, owning homes, having access to equity. Right? When they saw someone who was white out in public, they had to step off the sidewalk. These were the Black Codes. And as the Black Codes restricted those who were Black, it also allowed a type of social space in preference for whiteness. In other words, that these particular codes, these particular laws did what? Protected and privileged whiteness and propertized whiteness in what? Law. And by doing that, extended certain rights and accrued value. So when one was white in social spaces, in this instance, it was their right to walk on the sidewalk, and Black people had to get off the sidewalk in this instance when we're looking at the Black Codes. Laws that were passed after slavery was done away with. And even in this instance, we see that slavery goes away, but Black Codes show up, right? So there is that. And what this also makes clear is that as law prevents, it also allows. That the delimitation of one group is the permissive free will of another. Now, what's another example that we can look at? We can also look at the Chinese Exclusion Act. This was signed on May 6, 1882, and this banned Chinese workers from migrating to the United States. Take a look at this newspaper. What do you see that it says here? What this means is that they understood themselves and their rights to be propertized in law, and that particular property that comes about vis-a-vis whiteness extended rights and protections and social recognition and political recognition as well. Another thing that we can think about is Jim Crow laws had the same effect as black codes, and how the rights of white persons in the United States during the Jim Crow era were not only protected by law, but as in previous decades before Jim Crow came into effect, was also guarded by police as well. We can also think about Japanese internment or Executive Order 9066. This is not the only time executive orders have been used to achieve a racialized end. That doesn't just happen in the early 2000s. It also happens in 1942 via World War II, where those of Japanese heritage were forced to leave their homes. Their economic security was removed. In many instances, their homes were sold and taken over, and they became marginalized within society. Because they were interned in these camps as the war proceeded. And whiteness as a form of property allowed those belonging to that demographic to take over their property and to make exclusive neighborhoods. However, what should also be pointed out here is how whiteness became a strict scrutiny by looking at cases such as Ozawa versus the United States in 1922. And what this is about is Ozawa, who lived in Hawaii. He attended Berkeley and he was applying for citizenship. He was applying for naturalization. And we're going to get toward this at the end, of course, more particularly. And he's petitioning for citizenship, and his citizenship gets denied because they tell him, you're not white, therefore you cannot be a citizen. So he appeals. It goes all the way up to the United States Supreme Court. And there, Ozawa argues this. This is on page 182 of the October term in 1922 from the Supreme Court. Here's Ozawa's argument. Listen to this move closely. He says, quote, at the time the original law was passed, what law is he referring to? The 1790 naturalization law that says that whiteness is the requirement for naturalization or citizenship. He says at the time the original law was passed, which provided for admission of aliens being free white persons, there can be no question. But white was used in contradistinction from black, and free white persons included all who were not black. The latter were chiefly slaves, regarded as an inferior race. In other words, the argument that Ozawa was making was, I sure am not black, so I deserve the same rights as those who are white. In other words, he marshaled anti-blackness to make a claim on the state. But the state, having strict scrutiny in whiteness, told him, I don't think so. You still are not going to get citizenship because while you may not be black, you surely are not white. And that your skin tone does not register you as such. That is what the case found it, because his argument was saying that, hey, I am of fair skin, therefore I am white. And the law jealously guarded whiteness and said, not so fast. Because the property interest in whiteness had to be protected. In wrapping up, now let's make this real. Because as was stated during orientation, Critical race theory is not just historical, it also speaks to the contemporary context. So how might whiteness as property be reflected in the present moment in terms of the rights and value of a property that is ascribed only to a specific population being protected in law? What does that look like? It looks like mass deportation efforts. It looks like 14th Amendment claims and trying to roll that back, trying to get to the 1790 Naturalization Act. It looks like pardoning the J6 folks, right? It looks like attempting to colonize and take over Greenland. It looks like attempting to occupy the Panama Canal. It looks like changing the name of the Gulf of Mexico to the Gulf of America. It looks like the Keystone Pipeline. Because every single last one of those things protects the value that has been ascribed to and the rights that extend from whiteness, which is recognized in law. And so what Cheryl Harris is getting at here is not just a theoretical assertion, but she is saying that embedded in law is whiteness as property, and that law in and of itself is not only a social construction, but that it is inherently racialized. This is the foundation of whiteness as property. For our next lecture, we're going to move more deeper into the article and unpack more of what Cheryl Harris has to say. I'll see you in the next lecture. Peace.